Welcome to the masterclass on Torts Law 1. This is not just a summary. This is a deep dive into the legal principle that governs civil liability in Kenya. Whether you are a law student, panicking about your exams, or in your legal profession, today we are going to deconstruct the mechanics of intentional torts, negligence, vicarious liability, and strict liability. Okay, so let's begin with foundations of tort law. So what exactly is tortious liability? As you can see on the screen, it arises from the breach of duty primarily fixed by law. Unlike a contract where you agree to the terms, in torts, the law imposes the duty on you. And if you break that duty, the remedy is unliquidated damages, meaning the court decides the amount which you're supposed to pay as damages and not you. Now, a common confusion. How is this different from a crime? So, we are dealing with the difference between torts and crime, like tort law and criminal law. Think of it this way. Criminal law is the state versus the individual. Its goal is to punish the offender. Example, like what you see when somebody is arrested after killing somebody, he's taken to court and all that criminal process happens and he ends up in like a committee, okay? Or maybe he pays a fine. Like most traffic cases, what I've seen when I was in my judicial attachment, most traffic cases, the accused pays a fine for them. Okay. And in tort law, it's different. It's about compensation. The goal is to shift the loss from the victim to the wrongdoer, placing the victim back in the position they would have been in if the mess never happened. Okay. Okay, now let's examine the first category, intentional torts, specifically trespass to persons. And this is on assault. Assault is not hitting somebody. It's the act that causes a reasonable apprehension of battery. It protects your mental peace. If I point a gun at you in Nairobi CBD, even if it's unloaded, that's assault. Because you reasonably believe you are in danger. I mean you who I pointed the gun at. Okay. Okay, now let's compare with battery. So, what is battery? Battery is the intentional application of force without consent. This protects your bodily integrity. And listen, it does not have to be a punch in the face only. Spitting on somebody during an argument or an unwanted kiss constitutes to battery just as much as a physical fight does. We have false imprisonment. This is the total restraint of a person's liberty without lawful justification. Think of it in this way. A security guard locks you in a room because they suspect that you stole something. That's false imprisonment. Another thing that you need to know, you don't have to know that you're locked in somewhere. Okay, this was established in a case called Mering versus Graham White Aviation. In this case, they established that if you are locked in a room while asleep, your liberty has legally been violated. Even if you slept during the whole time, that was false imprisonment. So maybe the question in mind right now is, can you defend yourself against all these claims? And the answer is yes. The first defense is Volenti non-fit injuria, which translates to the voluntary assumption of risk. Look at the case of Tagwell versus Barnett. Okay, I'll give you an example. If you accept a lift from a driver who you know that is drunk, you have accepted the risk. You cannot sue them later if their drunkenness caused minor injuries to you. You consented to the danger. Okay, another example I would give is about football players. You know, some are injured during the sport. They cannot come to sue the club because of that. I'm highly assuming that there are contracts that are signed and there is a clause that states that you cannot sue them if you get injured in the pitch. And maybe there is some sort of compensation that's already put for you that you are going to receive when you're injured in the pitch. Actually, most clubs cater for the recovery of the player. Second defense is necessity. Sometimes you have to commit a tort to prevent a greater evil. In the case of Cope versus Sharp, the defendant trespassed on somebody's land to burn heather. Why? To stop a massive fire from spreading. The court said that this was lawful. If I'm walking by your land and I find that there is a fire, I'm allowed to go and stop the fire, and that you cannot sue me that I trespassed to your land. Trespass is another tort that we'll deal with in Torts Law 2 video. Okay. So now let's move to the majority of lawsuits in Kenya. This is the tort of negligence. To win a negligence case, you need to prove 3 things. One is duty, breach, and damage. The first is duty of care. This comes from the legendary case of Donoghue versus Stevenson. I know many have been acquainted to the case, where Lord Atkins said that you owe a duty to anyone so closely affected by your act that you ought to have known them in mind. The second one is breach of duty. How do we know if you were careless? We'll use the reasonable man test. We ask, would a prudent man in Nairobi have acted this way? If you are in a profession like a doctor or an engineer, the standard is high. We judge you against the other competent profession in your field. So if you are in the medical field, let's say you are a surgeon, you have a higher duty of care to your patients that you are operating on. Okay, and if anything happens, you are liable to that. Sometimes the negligence is so obvious you don't need to prove the details. This is res ipsa loquitur. The thing speaks for itself. In the case of Scott versus London, bags of sugar fell from a warehouse onto a passerby. Sugar bags don't just fall from the sky. The accident itself proves somebody was negligent. That's why the bags fell on the passerby. The third thing that you need to prove in negligence is damage. So what is damage? Damage is what happened to you as the victim. Let's say it was an accident. You were injured in the accident and maybe you lost your leg. That is the damage you received. You must prove the but-for test. But for the defendant's action, would the accident have happened? There is a limit to this, which is remoteness. As seen in the Wagon Mood case, you are only liable for damage that is reasonably foreseeable. If the injury is too bizarre or remote, you are off the hook. Next up is vicarious liability. This is where the boss pays for the sins of the worker. If a delivery guy hits a pedestrian while within the working hours, the company is liable. Let's say I'm the driver of company A and I'm within the working hours of the company. I hit a pedestrian on the road. The company will be liable for my actions since I'm an employee of the company. There is a but in all this. In the case of Twine versus Beans Express, if the driver goes on a prolific on his own, like giving a lift to a hitchhiker against the company rules, the boss is not liable. I'll give you an example. If a driver carries you in a truck, like let's say these trucks that carry containers, is the driver will be liable for anything that will happen to you. Okay, not the company. Finally, we have strict liability, specifically in the case of Rylands versus Fletcher. The rule says, if you bring something dangerous onto your land and it escapes, you're liable. It does not matter if you are careful. In order to prove this, you need 4 elements. 1, you brought a thing onto your land. You accumulated it. And number 3, it was an unnatural use of the land, like building a massive dam or keeping wild animals on your land. And number 4, it escaped. This was just an informative short video But if you want to understand more, you need to go back to your notes and like really dive into the notes and like look at the case law so you can actually understand the law itself. Okay, thank you for watching. Please subscribe, like, and share the video. Thank you.